Promissory estoppel. In the last podcast, I introduced the concept of consideration and the requirement for the exchange of promises between the parties to a contract. In this podcast, I will conclude the focus on consideration with a focus on the concept of promissory estoppel. At a high level, the notion of estoppel is one of prevention and restriction. In a case where estoppel arises, the party considered to be estopped is prevented or restricted from enforcing their strict legal rights, because to permit them to do so would be manifestly unfair. Let us take two cases to explore what we mean by promissory estoppel. The first is the case of Hughes and Metropolitan Railway. It dealt with the situation of a landlord and a tenant. A term of the lease between the landlord and the tenant was that the tenant had a duty to repair. The landlord gave the tenant notice that he required repair within 6 months. Shortly after giving the notice, the landlord and the tenant started to negotiate a sale of the freehold to the tenant. The negotiation fell through. At the end of the 6-month notice period, the landlord tried to evict the tenant, on the basis that their failure to repair had breached the terms of the lease. The tenant contended that because they had been negotiating with the landlord for the sale of the freehold, they had not done any repairs in that period, in the expectation that they would be buying the land and could then do with it what they wanted. The court held that, for the period of the negotiation, the landlord had led the tenant to believe that they would not be enforcing their rights, and the tenant had relied on this and not undertaken the repairs. The landlord was thus prohibited, from relying on his legal right of eviction, and that instead the 6-month notice period for the right to repair was deemed to have begun from the point at which negotiations collapsed. The second case is that of Central London Property Trust against Hightrees House. In the Hightrees case, the claimant leased a block of flats to the defendants at a rent of X, knowing that defendants were planning on subletting the flats. The Second World War broke out, and the defendants were unable to sublet as many flats as they had intended. The claimants agreed to reduce the rent by half. At the end of the war, in 1945, all the flats had been sublet, and the claimants said that full rent was payable again. They brought a case that, for the second half of 1945, the full rent was due rather than the half rent. The court agreed, saying that the reason for the half rent, the war, had ceased to exist by that point, and that the full rent was applicable again. The important part is a comment made by the judge, Justice Denning as he was at the time, that had the claimants attempted to argue that the full rent applied for the whole duration of the war, and that their promise to halve the rent was unenforceable through lack of consideration, their case would have failed, with promissory estoppel stepping in. Was this the right approach? It certainly extended the principle of Hughes, in that, in Hughes, the landlord's rights were simply delayed. In Hightrees, the landlord's right to the rent for the war period was removed entirely, even though there was no consideration. This is not a settled area of law, and while it is possible to try to pin down some of the requirements of promissory estoppel, it is impossible to be fully conclusive. There are probably 5 principles for promissory estoppel to exist. First, an existing legal relationship. Second, a clear, unambiguous promise. Third, reliance on that promise. Fourth, that letting the claimant enforce their strict legal rights would be inequitable. And fifth, the claim must be a shield and not a sword. In terms of the first principle, an existing legal relationship, the cases to date, both Hughes and Hightrees, involve parties which have had an existing legal relationship. Usually this will be a contractual relationship, but it potentially applies before a contract is made too, for example, parties in pre-contractual negotiations. Second requirement, a clear, unambiguous promise. The promisor must make a clear, unambiguous promise that they will not enforce their rights, although it would seem that a promise by conduct is sufficient for this purpose, given that there was no express statement in Hughes. Third, the claimant must rely on that promise, Traditionally, this will require the claimant to demonstrate some form of loss arising from reliance on the promise, such as entering into a contract which they would not have done otherwise, or having not done something which, but for the promise, they would have done. However, in high trees, the claimants did not obviously do anything other than benefit from the lessened rent. Finding reliance in high trees is difficult. The fourth principle is that it must be inequitable for the claimant to enforce their strict legal rights. For a defendant to benefit from this shield, inequitability is key, and the test is fundamental to the establishment of proprietary estoppel. Take the case of D&C Builders and Rees. D&C did some building work for Rees. Rees did not pay, and the builders asked repeatedly for their money. The wife of the defendant offered a full and final settlement in the sum of £300, which was considerably less than the amount which was owed. She knew that the claimants, D&C Builders, were having financial difficulties. D&C took the money and sued for the remainder. In what is probably a non-binding observation on the case, one of the judges, Lord Denning, mused on whether Rees could have sought to rely on promissory estoppel, namely that the builders had promised to accept the money in full and final settlement, and were now seeking to go back on their word. Lord Denning concluded that, to the contrary, it was Mrs. Rees's actions which were inequitable, as she knew the builders' financial state, and was able to exert pressure on them to accept the lessened sum, on the basis that they really needed the money. It would not be inequitable at all for the builders to seek full payment. The fifth and final principle, that the claim is a shield and not a sword, is very much the traditional view of promissory estoppel, and it remains the case today. What is meant by this is that promissory estoppel may be invoked to shield oneself from an inequitable claim, but it cannot be used as the basis of a claim in itself. For example, A promises to pay B some money for nothing in return. B, expecting the promise to be fulfilled, incurs some costs which they would not have otherwise incurred. A refuses to pay the promised money. A claim in contract is unlikely to succeed, as we've discussed, since no consideration flows from B to A. If B were to make an argument that, since B had relied on A's promise, and that A had not lived up to it, the principle of promissory estoppel should mean that the lack of consideration is overlooked and that A must pay B, the claim should fail. One cannot simply seek to establish a positive right based on promissory estoppel, but only a defence against a claim. In a slightly simplified form, those facts are akin to those in the case of Coombe and Coombe, which establishes that principle. To sum up, promissory estoppel is a shield which may be deployed to prevent a claimant enforcing their strict legal rights, where to do so would be inequitable. Thus, in the context of a contractual or a business relationship, you make a promise and the other party relies on it. Even if there is no consideration flowing from the other party, you may not be able to enforce what you might consider to be your legal right. On the one hand, this might be seen as a weakening of the requirement of consideration within a contract, if in fact there are bases on which the lack of consideration may not prove fatal to an agreement. On the other hand, perhaps relying too much on the notion of consideration might be unreasonable, where someone relies on a promise and acts accordingly. The promissory estoppel steps in to prevent a party from acting unfairly. From a practical perspective, promissory estoppel is usually deployed in situations where there is a lack of formality to an arrangement. If, for example, the tenants in Hughes had asked for the suspension of the obligation to repair to be put in writing, and had provided some form of consideration for this, even a nominal sum such as £1, it would have been much harder for the landlord to enforce its pre-suspension rights. In high trees, a formal agreement to vary the rent with appropriate review provisions, and on the basis that the discounted rate is a temporary matter, with the expectation that the rent returns to a full rate once preconditions have ceased to have effect, may have provided greater certainty for both parties. Of course, a party seeking to make a promise and subsequently backtrack on it might be worse off for having such a formal agreement, but it hardly seems right that the law should, as a matter of general principle, seek to protect someone who acts in such a manner. This concludes the examination of the requirement of consideration. In the next podcast, I will introduce the requirement that the parties to a contract must intend to create a legal relationship.